So I'm going to be talking about we have a lot of material to cover, but I will be covering some of the most common questions that we get. And what questions we get every day is, if I have a will and if my loved one had a will and has died, why is probate necessary? Well, at its very basics, probate is a process of having the executor named in your will appointed to be the representative of your estate. So your executor can't take the will, if you pass away, can't take your will to the bank and say, I'm the executor. The will itself does not give him any authority. There's a whole process that we have to go through. And this process can be very complicated in certain instances, but in most cases it's pretty straightforward. But the probate process is the process of satisfying the court that you are the rightful executor and the necessary people have been notified or signed off. So that's the probate process of having your will, what they say, admitted to probate. Each county has their own surrogate courts, so in which an executor is appointed. And it could be either your will, a codicil is an amendment to your will. We usually don't do codicils because you have to go through the same formalities and paperwork pretty much as a will. So if you don't have a will, New York State has a plan for you. It may not be the plan you like, but New York State has an estate plan for you if you don't have a will. That's called intestacy. And they appoint an administrator for your estate. So, but by preparing a will, you can designate who will be the beneficiaries of your estate. You can set up trust through your will. You can leave particular items of personal property. If you want to leave your 1965 GTO to someone, you can specify that. Certain dollar amounts or percentages. And you can appoint executors to administer your will. And if you have children under the age of 18, you can designate who will be their guardians if you and your spouse are deceased. So some of the myths about dying without a will is that your estate does not go to the state of New York if you do not have a will. There's a whole plan there of who gets your estate if you die without a will. For instance, if you have a spouse, everything goes to your spouse. If you have a spouse and children surviving you and you have no will, $50,000 goes to the first $50,000 goes to your spouse, and the remainder of your estate, 50% goes to your children, and 50% goes to your spouse. That may not be your intention, but that's what happens if you die without a will. But as we'll talk about, there's many assets that do not pass either through intestacy or your will. So there's also a simplified probate proceeding known as a small estate. If you die with no more than $50,000 and you have no real estate, there's a called voluntary administration. It's actually, I usually refer people, there's a do-it-yourself program on the court's website. I usually refer people that have small estates to this program that the courts have for small estates. So very often, probably about half the time people call me about probate or so forth. Probate's not necessary for a number of reasons, which we'll be talking about, is that more and more people's assets don't actually pass through this probate process. So anyway, what the probate process is, as I said, was for the court to issue certificates saying that the executor is the rightful person to administer the estate. So the executor files a petition with surrogate's court, and there's certain people that have to sign waivers saying that they have no objection to the will. We'll talk about that process. And other people are sent notice that they're named in the will. Also, there has to be filed affidavits by the witnesses to the will. And if there is no will, or if the will doesn't waive the bond, the executor may have to file a bond. You can disinherit your children, but you cannot disinherit your spouse unless you're divorced, not just legally separated but divorced. You can, or unless your spouse has abandoned you for 1 year, you can disinherit your spouse. So very often people that have a spouse that's in a nursing home, they may want to disinherit their spouse because they may, you never know what's going to happen. If you have a spouse that's in a nursing home, you may pass away before your spouse, and you don't want everything going to the nursing home for your spouse's care. So you may disinherit your spouse for that reason. So that's an example of if you do disinherit your spouse can file what's called a right of election against your will. So if you do disinherit your spouse still has a right to file a right of election to get at least 1/3 of your estate. So the way that works out is that if you were to disinherit your spouse that's in a nursing home and you pass away before your spouse, the county attorney's office will file a right of election on behalf of your spouse so that the county can recover Medicaid that they may have paid for your spouse's care in a nursing home. So many children think that they can't be disinherited, that they have a right to contest the will. Most will contests are not successful. There's a number of reasons that someone may have a right to contest a will. And this is something you all have to keep in mind in the will execution procedure. First of all, someone has to have, one grounds for contesting a will is someone does not have testamentary capacity. Now, to have enough capacity to write a will, you have to understand what a will is, what the process of will is, who your relatives are, and what your property is. Even someone with Alzheimer's disease can have testamentary capacity if at that moment that they sign their will, they understand all this. It's a very difficult burden, and this is a common reason people contact us. They say that their father or mother didn't have testamentary capacity when they wrote their will and disinherited them. So that's all. If someone's going to contest the will because they're left out of the will, one of the grounds could be testamentary capacity. And that's a difficult one to prove, and but this comes about through the process. Another grounds for contesting a will is due execution, and that's one reason why you shouldn't be using legal Zoom wills or doing wills on your own. So there's due execution, which is it's a rather simple procedure, but if it's not done correctly, the will could be thrown out. So due execution means that when a will is signed, someone comes in to sign a will, there has to be at least 2 witnesses, and after they sign their will, I ask them if this is their will and whether they want the 2 of us to be their witnesses. And that's a simple procedure, but it has to be followed. If it's not followed, it's not duly executed. So I've only been called in 43 years of witnessing wills, I've only been called in a couple times on a will contest. Now, there's a presumption that if an attorney is supervising the execution of will, that there is proper due execution. That's another good reason why an attorney should be involved in this. And these will contests can become very costly and brutal, really can become quite brutal if someone has any grounds for that. So I don't have to remember the circumstances, what happened in a will that was signed on April 26, 1980. All I have to say is this is my usual procedure. I've always followed this procedure where I ask the person if this is their will that they sign or whether they want the other witness and me to witness it. So I may not recall that precise procedure. So if that precise procedure is not followed, and the will can be thrown out. So the other ground, this is another ground that's difficult to prove. We've been involved in some of these will contests, is undue influence. So someone that's in a position of trust with you, it could be a friend, it could be your priest, it could be your lawyer. They influence you to write their will to make them the beneficiary. So this comes up commonly on will contests. It may be a neighbor that we say use undue influence for this lonely person. But there again, the person's contesting will has a burden to prove that the person that wrote the will did something they would not otherwise have done because of the influence of this person that they trusted. Another ground is duress. If someone holds a gun to your head to make you sign a will, that would be duress. Another ground is fraud, that the signature on the will is a forgery. It's not that actual person that signed that. So how does this all come about with will contests? Well, if you want to contest a will, and you're for your father or your mother that leaves you out of the will, the procedure is that you'll be asked to sign a waiver saying you have no objection to the will. If you don't sign the waiver, if you want to contest the will, you would not sign the waiver, because a waiver allows if everyone signs waivers, it allows the will to be probated and the executor to be appointed. So if you want to contest that will, you don't sign the waiver that's sent by the executor's attorney. They serve you with a citation to appear in surrogate's court. And surrogate's court was remote until this Friday. It's going to be all in person starting next week. Starting in person again next week. And you can go into court and say that you want to object to the will. And you have the right to examine the witnesses to the will. So the people that witnessed the will, you can examine them as to the circumstances of the signing of the will, who was there when the person signed the will, did they understand English, for instance, if they were from another country, and you can examine the witnesses regarding all the circumstances, and you have a right to examine the file of the attorney who prepared the will to see what the grounds are. And then after that, you can file your objections, determine what your objections are. That's the basic procedure. So there's many assets that do not pass through this probate process, which we say avoid probate. And as you can see, things can get very complicated sometimes with wills if people are going to be contesting wills and so forth. So there's a number of ways that your property passes upon your death without this probate process. So when people call me about probating an estate, the first question is were there any assets that were in the person's name alone, okay? And those are really the only assets, which we'll give you some examples of that. Those are really the only assets that are going to pass through probate. Assets that were just in the person's name alone, that didn't have beneficiaries, weren't jointly owned. So we're going to give you some examples here. Life insurance, in most cases, does not go through the probate process. It goes through the beneficiaries named in your will, in your life insurance policy. So that's an important reason to update your life insurance beneficiaries. We have some people that name their mother in the 1950s as their beneficiary, and their mother's no longer living. In that case, the life insurance is payable to your estate. If all of your beneficiaries and contingent beneficiaries are deceased, it gets payable to your estate. So life insurance could be a probate asset or may not be a probate asset. You can set up uniform transfers to minor accounts for your children and grandchildren. If you set those up, those do not go through probate. U.S. savings bonds maybe don't go through probate if you have joint owners on it or if you have those payable on death. As of about 15 or 20 years ago, your investment accounts, your stock accounts, can be in transfer on death. So you can designate there, usually it'll say on your statement that who you want to be the beneficiaries of your investment accounts. Your IRAs and 401ks, the same thing. If you designate on there who your beneficiaries are going to be, those do not go through probate. And there's an advantage to that because then it can be rolled over into your beneficiaries, their own IRAs and 401ks. You can also use your 401ks as vehicles. You can, if you have set your 401ks up as self-directed, you can use those to the 401ks themselves rather than being invested in stocks or bonds. You can use those to purchase real estate in a self-directed 401k. If you have annuities, okay, annuities, if you have beneficiaries in your annuities, those will pass without probate. Joint bank accounts, those are a problem. So most jointly owned properties avoid probate, except checking accounts that are called convenience checking accounts. So what are convenience checking accounts? Well, there's really no straight definition for that. Sometimes convenience bank accounts are determined when you open the account up. You know, you add your son or daughter on so they can pay your bills and sign your checks for you. Other ways, if it doesn't say there, convenience checking accounts come about just by the circumstances, by proving that it's your money and you added your son or daughter on there as a convenience. So why the difference? What's the big deal? Well, there's been hundreds of lawsuits over convenience checking accounts. So when someone passes away, it's something you have to keep in mind when you add someone on your account. When you have a convenience checking account, when you pass away, the joint owner has automatic access to that. But the cases say that if it's a convenience checking account, unlike other types of accounts, that should be administered through what your will says. It should be turned over to the estate. So it's something to keep in mind. It can result in quite a bit of litigation. An alternative to that would be to add someone on your account as power of attorney, because your power of attorney ceases to be in existence upon your death if you don't want to have that person, child, have access to your account upon your death. An alternative to discuss with your advisors is instead to put them down as your power of attorney. Powers of attorney are valid until they're terminated, or they automatically terminate upon your death. So unlike these convenience accounts, there are these, you can set up your bank accounts to be in trust for someone, payable on death to someone, or they also call it transfer on death. Those completely avoid probate. Be a savings account other than checking, so you can state on there, you still have control of your account, but you can say it's in trust for someone, or it will be payable on death to someone. This is a common one. Automobile, sometimes only assets when someone passes away, maybe bank accounts or automobile. You can transfer one automobile without probate up to $25,000 in value with a death certificate and DMV forms 349 or 349.1, depending on what your relationship is. You can transfer that. It's commonly used. Another way to avoid probate is just give things away during your lifetime. But if you want to maintain some sort of control, rather than give it outright, you may want to set it up as into a living or inter vivos trust. Susie Orman says everyone needs a trust. No, not necessarily. It's going to depend on your circumstances. There's certain assets you cannot put into the trust. But basically, a living trust is an agreement that you sign during your lifetime to place your assets in the name of this trust, and that avoids probate because the trust has provisions what happens to your assets upon your death. So, living trust can be irrevocable or revocable. So people that want to preserve their assets, if they have to go into a nursing home, the trust has to be irrevocable. You have to give up control. So people are commonly using irrevocable trusts to protect their assets if they have to go into a nursing home. But there's trade-offs. You have to give up control. So you cannot be the trustees of your own trust if it's irrevocable. It avoids probate. And you would not have access to the principal. You'd only have access to the income of the trust, like dividends and interest. Many people are setting up irrevocable trusts just to protect their house. And we'll cover that in a moment, because there are some disadvantages to transferring your house using a life estate deed. We'll talk about that in a moment, and that avoids some of those. So some people are just concerned about avoiding probate and not about preserving their assets if they go into a nursing home. So some people use a revocable trust if they are just concerned about avoiding probate, but the irrevocable and the revocable trusts avoid probate. Corporation stock, if you own stock jointly with someone, that can avoid probate. Can set up limited liability companies. People it's becoming quite a common use for vacation real estate. You can manage it for multi-generations if you want to have your cottage or recreational property available for future generations, keep it in the family, and to lay out the rules of who can use the recreational property. Okay, so real estate, and that's why when we're advising people, we need to see your deed as far as how your real estate ownership is. There's various forms of owning real estate. Some of them avoid probate, others don't. So one form of owning real estate is our tenants in common. That's where each person owns an equal share of that. So if it doesn't say joint ownership, it's to be tenants in common. If you own real estate with your friend as tenants in common, your share, whether it's a half or a third, will go through the probate process according to what your will says. The form of ownership that avoids probate is joint tenants with a right of survivorship. So if it's joint tenants, you own property with a friend or a brother or sister as joint tenants, or maybe you inherited the property that way, it was given to you as joint tenants, it automatically goes to the survivor without probate. Tenants by the entirety is ownership by husband and wife. If you and your spouse bought the house when you were married and your spouse dies while you're still married, the house automatically transfers to you without probate. So this is another common question we get. People call up and say that their husband died and they want to put the house in their name. But that's not necessary. The house automatically became theirs upon the husband's death without having to go through probate or whatever. When they go to sell the house or refinance the house, they will have to file an affidavit that they were married when they bought the house and they were married when the spouse died, and that will show that they have title to the property. Another form of real estate ownership is life estate. People commonly as preserving their house which many people, it's their major asset, preserving their house in case they have to go into a nursing home. They prepare a new deed to their child in which they keep life use, and then which says that their child is called a remainder person. They get the house immediately upon their death. So many people do this. If you do this 5 years before you go into a nursing home, it won't be considered a resource when you qualify for nursing home care. So there's some disadvantages to that as opposed to putting into a living trust. Both the life estate and a living trust, they avoid probate, and both of them you can still get your property tax exemptions, your senior exemptions and so forth. You have to reapply for them, but you're still entitled to that. So, what are the disadvantages of doing this, of a life estate versus putting in a living trust, is that if your children go bankrupt, then there will be a substantial amount of money that's had to be paid to the bankruptcy trustee, probably the majority of the value of your house. And this has happened before. I've seen it happen. Children have gone bankrupt and sometimes not listed the house because they have what's called a remainder interest in the house. Even though they don't have current use, with a life estate deed, you have the right to occupy the property. No one can kick you out. You can do whatever you want with the property. And upon your death, it automatically goes to your survivors. So, disadvantage that if your children go bankrupt with a life estate deed, as I said, a substantial amount of money to be paid to the bankruptcy court. If they're sued and have money judgments against them, there'll be liens against the house. So there's two ways of avoiding this. If you insist you want a life estate deed, sometimes people deed their house to the child least likely to go bankrupt or least likely to be sued, and then that child signs an affidavit that they will share the proceeds with their siblings when the property is eventually sold. So the other alternative, like I said, is rather than deed your house to your children in their names alone, you deed it to the trust, which they'll be named as trustees. So if they get sued or go bankrupt, it does not affect your property at all. So this is with an irrevocable living trust would achieve the same goal, and plus you can put other assets into the living trust that you want to protect. So something, again, to discuss with your advisors, your investment advisors, and your legal and tax advisors. So what's going to be best in your particular situation. Excuse me. Okay, another common thing in which people may not need our services is, and many people are not aware of this, and I have all this information on my website too about all the ways you can go through probate processes without an attorney. But another one of these is, it's called Surrogates Court Procedure Act 1310 affidavit for bank accounts. It can be used for unclaimed funds. If you want to check on the controller's site, if there's dormant accounts or turnover to the controller, they accept this affidavit too. This is another way. You don't have to be appointed as an executor to get access to someone's bank accounts. Many of the banks have their own forms, but surviving spouse can claim up to $30,000 in a bank account without going to court if you ask the bank about this form, or investment accounts or unclaimed funds and so forth. Other relatives can claim up to $15,000 in accounts, or if you pay the funeral bill for someone, you can get access to these accounts. And there's some more distant relatives can also claim up to as much as $5,000. So this is without going through the probate process. You can get access to bank accounts. Like I said, there's ways of, and just like there's ways of getting around having to go through the probate process to transfer a motor vehicle through the DMV form. So, So every person's case is different. We, in the process of preparing wills for people, we have to fill out a 2-page will intake form. I have those here. So we can see, so we can advise them properly, see which assets are non-probate assets they own, who they want to leave their estate to, and so forth. Probably one of the most common situations we're coming across is sibling rivalry and brothers and sisters fighting furiously, brutally fighting amongst themselves, even before their parents are deceased, and even after they are deceased. So that's something you have to deal with. We also, unfortunately, many people are estranged from their children. They haven't seen their children for many years, so that they can take care of that in their will, and they can always change their will later on. But there's various considerations that you have to talk to your advisors about. I had one client who had an estate of about $2 million, and he didn't have a will until I convinced him to do a will shortly before he passed away after he was diagnosed with cancer. But his closest relatives were cousins, and his cousins would have inherited from him if he didn't have a will. And one of his cousins had actually looted his home when he was in the hospital and tried to be appointed his guardian to take the rest of his property. So fortunately, he did sign a will just before he passed away, leaving most of his money to the Salvation Army and the church. So, very often people say, I don't know who I want to leave their money to. I don't have anyone to leave it to. But there's very worthy causes that you can leave it for, but leave it to someone that's deserving of it rather than some of your relatives that you've never seen or that you may dislike. So the various considerations are what your relationships are with your children, whether you want to protect your assets. Like I said, an irrevocable living trust may be necessary to protect your assets in case you go into a nursing home and to qualify for nursing home care. Most of our clients don't have issues with estate taxes. When I first started practicing estate taxes, estate planning was all centered around estate taxes when the limits were like $250,000. Right now, the federal exemption is $12.06 million. So, and I have those details in my newsletter too. And the New York estate tax exemption is 6.1. So New York no longer has a gift tax. If you can believe it, New York actually eliminated a gift tax a long time ago. The federal U.S. government does have a gift tax. It's all included with this lifetime exemption of $12 million. So many of you may have heard, just so clear that up, may have heard where you can give away $16,000 per year away to as many people as you want. Used to be $10 million. And now it's, $10,000 per year. Now it's $16,000. So that has nothing to do with qualifying for Medicaid. So you can give $16,000 away to as many people as you want without having to file a gift tax return. Now the idea of that was, in addition to people having the lifetime exemption of $12 million, they can give away $16,000 per year to as many people as they want. So there's some myths about that. You still will be disqualified from Medicaid if you give away this $16,000. Nothing to do with qualifying for Medicaid. Something to keep in mind. So we have to decide whether that's like I said, some people's main objective is to qualify for Medicaid and leave as much as to their children. But like I said, if you want to get into a good nursing home, even for rehab, you're going to have probably about $100,000 in your name and not have made gifts in the past 5 years. Unfortunately, even some of the 5-star nursing homes are not that great. So if you don't want to end up in a 1-star one 50 miles away, you may want to think about yourself rather than your relatives. Just something to think about. Also, one of the main points about my Medicaid and this ties in with your gifting. One of the main points of my Medicaid seminar is that you need to have a power of attorney with gifting powers in it, okay? So many, and that goes back to, that could be one of the most valuable tools you have if you've never done any planning for Medicaid, and you end up in a nursing home where you can preserve half your assets. We'll talk about that on Thursday. But basically, the old powers of attorney, when we talk about, you can see the old powers of attorney from the 70s and 80s, limited gifts to $10,000 per year, and that was the old exemption for gift tax, just so you know the background of that. So what you do need really is a proper power of attorney with gifting powers so that your agents can preserve your assets in case you have never made any estate planning. So there's something you should discuss with your advisors about having the proper power of attorney to qualify for Medicaid. And that all ties in with the gift tax exemption. Privacy, if privacy is your goal, trust, achieve that goal because estate proceedings are all public proceedings. Those records are all public. Now you can they're fully accessible online now, circuits court records for most of the courts throughout, most of the 60 courts throughout, circuits courts throughout New York State. So trusts, living trusts provide privacy. Another consideration is second marriages. We think about husband has children and his wife has passed away and he goes to a second marriage and he and his second wife make out identical wills leaving everything to each other. Otherwise it goes to his children when both of them are gone. Well, but if husband dies first, second wife is free to change her will. And we encounter this quite often with stepchildren saying, well, Dad always said I would have the house, but my stepmom is ghosted on us and we have no idea what's going on. Well, he may have changed his will, where he may have put the house in the second wife's name. I may have done a number of things, and this is what happens very often. Sometimes people, sometimes when you appoint a power of attorney who's not trustworthy, they may move things around on you. They could change beneficiaries on your accounts so that your children don't get anything. So if you have your second wife or someone or an untrustworthy child as your power of attorney, something to keep in mind, they can change accounts around so that there's no probate assets. So regardless of what your will says about leaving things to your children may not get anything. Something to keep in mind with second marriages, and there's always, well, most of the time there's bad feelings between stepchildren and their stepmother for a number of reasons. So there's differences in legal fees depending on what type of plans you want to make, estate planning. Like I said, financial security for your family is a consideration in your estate planning. How much income and cash flow you need. With irrevocable trust, you're going to have limited access to your assets. And maintaining control, that's all something you have to talk with your advisors. So if you want to preserve your assets, if you go into a nursing home, you have to give up control, either by putting it into a trust or by outright giving it away. So that's something you have to think about. Business succession and continuity of ownership and management of your business. There's some vicious fights among family members about passing a business on to the second generation. There's also very often, many business owners haven't made any provisions to what happens if they do pass away and haven't made arrangement for someone else to carry on their business. If you're not a limited liability company or a corporation, if you're just an assumed name, a DBA, and you pass away, your business passes away with you. So it's something you need to, if you're concerned about your employees or your family taking over the business, you need to think about that. minimize the cost and delays of probate if that's a concern of yours. Also, medical decision-making in the event of disability, have advanced directives for people to make decisions for you. We'll talk about that on Thursday with healthcare proxies. Financial management, that's where you need power of attorney and trust can provide financial management in the event of you're disabled. So power of attorney, you can designate your power of attorney to take control of all your financial matters if you become incapacitated. Trustees of your trust can manage your assets and prevent you from being exploited financially. Many people would rather provide for their pets than their family members. That's an important thing about who you want to provide for. It's your charities or for pets. You can set up trusts for your pets to provide for their care. As I said, prevent financial abuse. And when should you update your will? That's something, another consideration is when to update your will. A number of reasons. If there's been a major change in your financial status, if you adopt a child or a pet that you want to provide for, if the executors or trustees or guardians in your will have moved, become incapacitated, or been convicted of felony, executors cannot have felony convictions for the most part. If your spouse dies, you may or may not need to revise your will. If you get married, if you get divorced, if you move to another state, wills are generally valid. Most other states will generally accept a New York will, but the laws are considerably different in some states, for instance in Florida, so you should consult with an attorney in that particular state. If you have a beneficiary that becomes disabled and goes on Medicaid or SSI, and you want to leave something to them without them losing their benefits, you can leave money to them in a supplementary needs trust so that they can still have purchase luxury items, and they can still be a beneficiary without losing their Medicaid or the SSI, which is based on their resources. If you're creating a living trust, then you may want to revise your will. If you want to have equal distribution of your assets and you've set up some of these non-probate assets, transfer on death accounts or life insurance, if you want to have equality amongst all your beneficiaries, you may have to adjust your will in keeping that in mind. If you want to disinherit a child, you may want to change your will. If you've made gifts during your lifetime, such as transferring your house into a life estate deed, or if you want to leave a specific item to someone, a valuable item to someone, antiques or cars, to revise your will for that. So, the benefits of avoiding probate: you can save a considerable amount of time and costs. Now, the probate process, as far as the executor getting appointed, it can take months or it can take longer. We're going through all the procedures of filing the necessary paper to the executor to be appointed. Unlike a trust, when someone passes away, the trustees have the power to make the distribution according to your trust, or other non-probate assets. For instance, life insurance claims are submitted to the life insurance company. So there can be time delays in having your estate distributed if it has to go through the probate process. It all depends on what court there is. Some courts, it could be years. There was some in Kings County in New York City. Nothing was going on for about a year because of the surrogate court judge who ended up being removed. So that's also something you have to keep in mind about the time involved and the cost to probate an estate. You can still maintain control of your assets by avoiding probate. There's privacy. It's not, as I said, the probate process, that's all public. Living trusts, for the most part, are private documents. It can avoid will contests by avoiding probate. And you can avoid Medicaid recovery. Now, when someone passes away that's in a nursing home, there is no Medicaid recovery against non-probate assets. There was, about 10 years ago, they changed the law in New York State for about 11 months, and it didn't make any sense. But currently, something all to consider about when someone passes away that's been in a nursing home on Medicaid, the county will file a claim against that person's estate in surrogate's court against the probate estate. There is no claim to be filed against non-probate assets. Something to keep in mind. As I said, benefits of avoiding probate, like with second marriages and setting up a trust. The risks of avoiding probate, see very often people have living trusts created. This is one of the common mistakes. They set up a living trust agreement, but they never fund the trust. Okay, the living trust doesn't help you at all unless the assets are in the name of the trust. So to fund a living trust, like with a house situation, you would sign a deed over to your trustees of your house to put it into the trust. For your investment account, you'd have to change the names on the accounts from your individual name to the name of the trust. The Henry Miller Living Trust could be in the name of the trust if you want to do that. So very often people don't take that next step. They create the living trust agreement, but they don't fund it. So, and you don't have to put all your assets in the trust. If it's an irrevocable trust and you want to have access to some of your money, you may want to keep it separately, and you talk that over with your advisors. As I said, the convenience bank accounts result in a lot of litigation. Also, if you avoid probate, you need to coordinate with the distributions in your will. And joint ownership can result in some issues. And life estate, if you're sued, if you have joint ownership of real estate with someone and that person's sued, there could be liens against that. And there can be complications with joint ownership if one of the owners is going through a divorce. So.